Hi, everybody, and welcome to L Said What. Those of you who do happen to come past this live stream. So, I have a small sub count, and I'm building my lives right now. In Law and Crime Network just released Alec Baldwin's interview. So, I don't expect to see many people in the live, but I still wanted to go live and I wanted to talk about the pretrial hearings that happened on Monday. So today was jury selection. Alec Baldwin is charged with involuntary manslaughter and he's standing trial this week in Santa Fe, New Mexico. How you doing, Sleuth? Sleuth, can you hit one if my volume is good? So Alec Baldwin, what an actor and a producer on the set of Rust, October 21st, 2021. A cinematographer, Hannah Hutchins, she was shot with a live round, and she was shot while I believe they were rehearsing. And Baldwin was actually, from my understanding, holding the gun. So there's already been a conviction. There's a conviction of the armorer, and she received 18 months. So this is not a joke. And Judge Marlowe was not playing yesterday. So Hannah Gutierrez Reed, the armorer, she was tried and convicted, and now Baldwin, his trial has begun. So I wanted to talk about the fact that pretrial hearings are usually extremely boring, but they are the meat of a trial because pretrial hearings is where the state and the defense are going to argue to the court what they want to be let into evidence, what they want out of evidence, and what evidence that is let in. Each side can use some sort of rule to try to limit it. And there's also more than one way to climb a mountain. So, even in this pretrial hearing, you can see where the state is trying two different methods to convict Alec Baldwin, trying two different methods. First, I wanted to talk about how there's a lot of, I'm going to just put it bluntly. The attorneys for the state and the attorneys, the defense attorneys, they don't like each other. They don't like each other. There was literally a motion put forth by the state, asking the court to disallow, to not allow the defense to accuse the state of prosecutorial misconduct. Basically, I heard motions, one, possibly two, that were behavior motions, asking the court not to allow each side to behave in a certain way because these two teams have met up before in Hannah Gutierrez Reed's trial. So the state, that's, listen, usually I'm not really harsh on attorneys. An attorney can be working, you know, multiple multiple felony trials, multiple violent crimes at one time. On top of that, one or two, three civil cases. So I really tried not to go hard on attorneys because I know how laborious the work is. But when it came to, for instance, the propensity evidence, I thought that the state was sloppy. When, no, not the propensity evidence, when the state argued to get in the producer liability theory. And that's what I'm going to talk about in a minute. But I wanted to cover real quick, the state, it looked a little sloppy to me when there's a motion to exclude late filed witnesses. Okay. So in a trial, there are no surprises. Remember watching, maybe Law and Order or some show like that. And at the end of everything, I remember on one of the Godfathers, and hi Susanna, thank you. And you know, some witness would come in and stand at the back of the courtroom. Well, in real life, in American jurisprudence, there are no surprises. That's the rule. The rule is there are no surprises. And without good cause. Witnesses added very late that the other side don't get to interview, don't get to investigate, then there's a good chance that that witness can be prevented from even testifying, because just out of fairness, adding witnesses late, could it could be used as a tactic. But even if you're not thinking that it's being used as a tactic, it causes time delays, and it can ultimately cause the defendant to have an unfair trial. If an expert is going to testify for the defense, then the prosecution has an opportunity to interview that expert before the trial to get a report from the defense exactly interview. There's no way there could be prejudice to the state that they weren't given enough notice. And listen, the state definitely said that these two witnesses being added late is a tactical advantage. To me, all of that made the state look bad. All of it made the state look bad. I mean, my goodness. Ryan Winchester was the state's own witness. So him being on the witness list, they knew his expertise. They had already had a chance to have an interview with him in the previous trial. And according to the defense, the state didn't even respond to inquiries about Zook being on, for a pretrial interview. Okay, I'm going too far with that. That's enough. But all I wanted to do is say that the state saying that that it was not unnoticed, and that it was a tactical, you know, um, advantage that the defense was trying to gain over the state. I just want to say that that's weak. So, can you imagine if, for instance, you are charged with involuntary manslaughter like Alec Baldwin, and the state wants to allow in evidence of your bad temper, cursing, probably red in the face? Well, the court ruled, and I agree with the court that it's highly prejudicial toward Baldwin, and does not answer the burden that the state has to prove, which is willfulness and recklessness. Baldwin cursing and having bad temper, in my opinion, I agree with the defense, is the state trying to slip in what's called propensity evidence, character evidence that is just there to make the defendant look bad. And in this instance, considering that Miss Hutchinson was shot, I would say that it would suggest malice on, versus willfulness and recklessness. So I can't believe that the state even tried to get that in. So, Mr. Johnson is standing trial for beating up Mr. Smith. The fact that Mr. Johnson is a blowhard and an a-hole doesn't tell the jury whether or not Mr. Johnson beat up Mr. Smith. But it does make Mr. Johnson look really, really bad. And if he looks, really, really bad, then maybe he did beat up Mr. Smith. So no, 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 no. What the court wants, what the rules of evidence require, what American jurisprudence, requires, is that the jury, decides. Her and run back to the prosecutor's table and ask her co-attorney, her co-counsel. She wasn't even positive. So she's working on the fly. And I'm not going to assume that that's her fault. I haven't checked to see who lead counsel is in this case, but she was working on the fly in those pretrial hearings. Now, so Carpenter, he was responsible, according to the state, for safety on set. And that's why the state wants him as an expert witness. And the defense says that, you know, he created safety bulletins pretty much with SAG guidelines. And these guidelines are for actors, they're for producers, they're for pretty much anybody, it sounds like, who is on the set involved with the production. And the defense says, and by the way, those guidelines that Carpenter, was responsible for, the state said in Hannah Gutierrez Reed's trial that those guidelines violated New Mexico law. I just think the state looked really, really bad in those pretrial hearings. And so the 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 court says, listen, he can go, and this is literally what Judge Marlowe said about Carpenter. He can go sit like over there in the gallery and he can maybe listen. And if he wants to opine, meaning give his opinion, if he wants to opine on something, then maybe he can. Basically, Carpenter's out as an expert witness. Now the state wants to call, three expert witnesses. Two of them have never worked as a producer. One has limited experience, and not none of them worked on the set of Rust. And there are excuse me, producers that were on the set of Rust, which brings me to the producer actor dual role liability argument. It was horrible. It was horrible. Besides the fact that the defense, in my opinion, proved that it really was not on notice that the state was going to proceed with this alternative theory. The state wants to proceed with two theories: that Alec Baldwin, as an actor, acted willfully and recklessly, causing the death of Miss Hutchinson with a firearm, and the state also wants to put in front of the jury another theory: that as the producer, Alec Baldwin was the boss. And as the boss, he was in charge. And he was in charge of safety on the set. How he and not all of the producers would not be in charge of safety on the set and therefore on trial, I have no idea. Judge Marlowe brought up the fact that there are multiple producers on this set. Think about this. Alec Baldwin walks out onto the set. He shoots a scene, and in the middle of shooting that scene, he begins to shoot a scene, and in in his capacity as a window washer, and he is driving, and he's driving home, and he's driving to a job to wash windows, and he's reckless, and he hits your car, right? So he's reckless. He's in his company vehicle. He is on a way to do a job that he normally does for that company. And so, as the injured party, you can sue him and you can sue his employer. And that is the legal theory that I feel like the state tried to apply here. Only it is not that clear. It's not that clear. And I've already listed the reasons why. And like Judge Marlowe, the first thing I say is, well, there are multiple producers. There's an entire other entity that has to approve the decisions in the making of the movie. There's the armorer who did not notice that there was a live round mixed in with fake rounds. And then here we have Baldwin, right? And this is the last thing I wanted to mention. What was let in? Why I say Baldwin is not out of the woods. He's not out of the woods because Baldwin, apparently, the state says that it has evidence of Baldwin acting recklessly on the set with a firearm. And I think that is highly prejudicial. And I think that that goes to say that this was not a one off, that this was